Meeting back to order. I'd like to welcome back to the meeting the Standing Senate Committee on Aboriginal Peoples, continuing our work on a pre-study of Bill C-92. The committee is pleased to welcome from the Bakankeg Mi'kmaq Nation, Chief Paul Prosper, from the Mi'kmaq Rights Initiative, Jennifer Cox, barrister and solicitor for project lead for Enhanced Child Family Initiative. I still can't get that right. And from the Mi'kmaq Family and Children's Services of Nova Scotia, Paul Morris, lead counsel. Thank you all for taking the time to appear before us today. We will begin with opening remarks with Chief Prosper, followed by Ms. Cox and then Mr. Morris. Chief Prosper, the floor is yours.
Thank you. Gwain and up to Waliestikburg. Honorable committee members, it's an honor to be here on the traditional territory of the Algonquin people. My name is Paul Prosper. I am Chief of the Bakankeg Mi'kmaq Nation. I am here on behalf of the Assembly of Nova Scotia Mi'kmaq Chiefs, which exists as an institution of governance for the Mi'kmaq of Nova Scotia. For the past 4 years, I have held the justice portfolio for the Assembly and have become quite intimate with child welfare related issues from a provincial perspective. The Mi'kmaq occupy roughly about 5 provinces within the Atlantic. We have our own creation story. We have legends that speak to a time when the ice started to walk on the land. We have a traditional government, the Sante Mawiomi, the Mi'kmaq Grand Council. We have rights, both Aboriginal and treaty rights. We have pre-Confederation treaties, which have been recognized by the highest courts in this country. Throughout our history, from scalping proclamations to pre- and post-Confederation legislation, including the Indian Act, we have endured despite the failed good intentions of the federal government. We not only survived, but thrived. Before the arrival of Europeans, we existed as independent nations governed by our own customs, values, and traditions. The original instructions of Niskam, or Gisselt, the creator, provided a basis for us to live. We do have an inherent right to self-government, and this is independent of any legislative recognition, and it's embedded within the constitutional framework of this country through Section 35. With respect to our position on Bill C-92, we support the bill in terms of its recognition of the inherent rights that Aboriginal people have to children, families, and communities. But it's unfortunate that this bill doesn't have any substantive provisions related to funding. We'd like to share a bit of our experience, all of us here, on what we have undertaken within Nova Scotia. By way of background, in 2014, the province of Nova Scotia sought to amend an act that was roughly about 27 years old, known as the Children and Family Services Act. As it existed within the Mi'kmaq Nation, as it relates to children, there was a fair bit of controversy related to children and the care and protection of children internally. But we decided to put our children in the middle and put our differences aside to work together to create a path forward. Our path, our approach involved an intermeasure, which involved realizing positive amendments to the Children and Family Services Act, but also a long-term approach involving Mi'kmaq laws over Mi'kmaq children. It was a collaborative approach, and it still exists as a collaborative approach involving our partners, the province of Nova Scotia, and many justice stakeholders within Nova Scotia as well. And this resulted in 25 amendments specific to the Mi'kmaq within Nova Scotia, an act, the Children and Family Services Act, which had no previous provisions dealing with Mi'kmaq people. These amendments were realized in 2017. And from that experience, we have come to seize the benefits of this change. We know that there are less foster care for children who are in care, more customary care. We have a family group counseling known as Wikimanage, which provides a preventative approach to prevent apprehensions from taking place by early intervention, and reflects the teachings of our elders, where we need to fix things before they break, as one have put it. So certainly the benefits we have seized and gained within Nova Scotia, we don't want this bill, this federal bill, to interrupt that momentum that we have gained. We are tired of watching our children and families and communities torn apart by a system that frankly just doesn't work. In the early beginnings within Nova Scotia, I was often curious and would have discussions with then Minister Bernard over my role as chief within my community. More specifically, the role of community. We realized that there are basic building blocks that our children must have with respect to identity, culture, language, tradition, the spirit of a people and of a nation. This idea of connection and belonging, which is a basic cornerstone to a healthy community. We realize that solutions to our problems involving child welfare must come from within, where there has to exist a certain environment in order for this change to take root. Often, provincial laws and policy don't reflect the realities within our communities. Self-government provides a mechanism, a way to offer traditional and practical measures to allow us to take care of our children and our families. We know this through certain experiences we have, for example, within Nova Scotia. If we're thinking about elders in terms of gifts or money for their services, we have to seek provincial approval, which often causes red tape and time constraints regarding that. Regarding customary care, there are prohibitive provisions that provide that if a person has an offense, a criminal code offense within the last 5 years, and this could be a very minor offense, that they are prevented from being considered for customary care services. So there is certainly a need for change. Just like to provide some comments on funding and transition. Our experience within Nova Scotia through the amendments to the Children and Family Services Act provide that legislation alone doesn't allow for change to take place. It takes a coordinated approach. It takes education, capacity building, governance structures, infrastructure, stable funding, and a comprehensive justice strategy. As Indigenous people, Indigenous cultures, wisdom, a certain care and concern we possess, and obviously throughout time, a certain prophecy and foresight that we have as people and as nations. Throughout history, our people have benefited from the original instructions provided from the creator, Gizulk, or Niskam. And it's through the course of history that these original teachings have been somewhat compromised. These teachings reflect an idea where every human matters, and that doesn't depend on their role, their position, or certain accreditations. It flows from birth. This, we believe, will provide a vision where we start to redefine what it means to be human throughout this project, throughout this process, for the benefit of our communities and for generations to come. Willalio. Thank you.
Thank you, Chief. Ms. Cox.
Good morning, Senators, and thank you very much for inviting me to come here today. My name is Jennifer Cox, and I am one of Nova Scotia's Mi'kmaq lawyers with an extensive background in the area of child and family services. So the perspective that I speak to you today is from that perspective as a lawyer who I had to calculate last night. It's almost 24 years that I've been practicing law, and the last 10 years in particular have been in the area of child and family services. And I also have a lot of experience with the processes that the Chief had mentioned with respect to the legislative changes we went through in Nova Scotia. I was working for Nova Scotia Legal Aid at the time, and we were working through those changes. So I've come, we did submit a brief, but it wasn't translated, I don't think in time, so the Senators do not have a copy of it, but we do have specific suggestions with respect to Bill C-92. So the technical pieces are in that brief, and I don't propose to sort of read verbatim through those, but I would like to go through some of the comments that we have in the brief itself. And I think it's important, first off, for everyone to understand that we take the position, or the Chiefs take the position, that we were not co-drafting Bill C-92. We had one engagement session that I'm aware of in Prince Edward Island in October of 2018, and that was it. So we did not have an opportunity to participate in the co-drafting of this bill. So we do take issue with that characterization. Also, I think it's important, as the Chief indicated, we're supportive of Bill C-92 because it provides that rights recognition provision. We obviously have concerns about the fact that there's no funding in it, and our submissions, written submissions to you, make some suggestions to pull the language from the preamble into the body of both Section 18 and Section 20 of the bill itself. And I think, as the Chief also indicated, it's important for you to recognize that the positive changes that we have seen in Nova Scotia are not just because of the legislation. Although there were changes to the legislation that reflect positively for our communities, it isn't just the legislation that has made the change. It's the group of individuals who are now working together. We all came together as a team. So Mr. Morris, who is to my left, Chief Prosper, and a number of other individuals, Angelina Amaro, Heather McNeil. There were a number of Philippa Picto, a health director. We all volunteered our time to come together to work on the legislative changes, because we had a very short window. The government gave us less than 3 months to look at the bill that they were tabling and make some suggestions. And as we developed that team, we developed this infrastructure, this governance model that was informal, off the corner of our desk, but we worked through the legislative changes, and then we continue to look for changes to policy. So the development of the Wigimanaj-Gigmana, the family group conferencing model that we are now using. And quite frankly, I think the province of Nova Scotia is now beginning to borrow the implementation of customary care arrangements. There's recently been some changes in the policy in the province of Nova Scotia, so those are now funded. So we have many more customary care arrangements. And I think to some degree the province of Nova Scotia is now embracing the suggestion that customary care is a good idea, not only for our communities, but for their communities as well. So I think it's important for you to understand that although the legislation is important and the changes to the legislation are important, and definitely the rights recognition provision in Bill C-92 is important for us as we move forward with our own, the vision of the Chiefs, we also have to take into consideration there are people that are required and information resources required to make sure that we can all take these tasks forward. We can't do things with just a piece of legislation. So, it's very clear to us that the funding is the big piece that's missing from C-92, and I'm mindful of the fact that the Senate has limits with respect to what it can prescribe in terms of the funding provisions, but for the record, it's important that that be included. The brief that we submitted is also done in order of priority. So there are a number of suggested amendments. The first is funding. So that is our number one priority for amendment. Number 2 is enhancement of the jurisdiction clause. So the jurisdiction clause in Section 18 does not mention the United Nations Declaration on Indigenous Peoples. We're asking that that be also inserted. I think it's also important for you to understand that as we look at this bill, we haven't completely picked it apart. We haven't had the time. We have realized that the bill may lose momentum if we get too caught up in too many amendments. So we've been strategic in the way that we've approached the submissions to both you and to the House that we will be doing later today. The inclusion of Jordan's principles, so Section 9(3)(e) of the bill basically talks about Jordan's principle, but let's mention Jordan's principle. Jordan's principle has been a huge relief to our communities and made a big difference in terms of the development of services, the ability to do preventative and placement options. It's a big deal, and it should be mentioned specifically, not just referred to. It should be specifically mentioned. The best interest of the child section, Section 10 sub 3, we make some suggestions to 10 sub 3, the first provision there. We ask that there also be the inherent Indigenous legal and community standards observed, as well as the list. So we're making some room for that to be included immediately so that courts and others can reflect upon the Indigenous legal and community standards, because that's where the frustration comes from when you practice in the area of child welfare, is that the communities and the leadership are not listened to in the system. So it's important that we look at that. We also suggest that Section 9 be referred to in the Section 10. So the principles of cultural continuity and substantive equality be cross-referenced in Section 10, because Section 10, the best interest section, seems to be a fairly weighty consideration in the bill. And if you don't cross-reference those sections, I think you lose, the principles are not as weighty as the best interest section. Sorry. With respect to Section 10 sub 3, G, the family violence provision, we've asked that that be removed completely. When you're working in the area of child protection, family violence is usually considered a protection ground, so a reason for removal. It's not normally something you see in a best interest environment. So as I've suggested in the brief, it seems like it's out of place. And I think it has the potential to confuse people and increase apprehensions because of that confusion. We've suggested that the definition of care provider exclude foster parents whose sole connection to an Indigenous child is by way of a child protection placement. And I think inadvertently that definition allows foster parents to have standing in a legal proceeding, and that's not necessarily going to be helpful to this bill. We're looking for a 3-year review, not a 5-year review. We would like to see some reference to courts in the application of sections 8 through 17 for ongoing child protection matters, so that the courts that are normally hearing child protection matters can continue to hear or apply Bill C-92. But we'd also look for some provisions that would allow perhaps the federal court to get involved if there were issues with the mechanical parts, so the coordination agreements or other pieces that were holding up the implementation of the bill. Section 12, we make some suggestions and bring forward some provisions, some documents from Nova Scotia. And I think this is a really good example. So attached to the brief, you will find, once you see it, the notice that goes to our communities, as well as the document that is used to respond, for the communities to respond to the notice. That's a really good example of co-drafting. So we worked together with the province of Nova Scotia and the courts of Nova Scotia to develop those forms. And I think that those could be useful and when you look at Section 12 sub 2, because we do some identifying in those documents. And I think it also speaks to the intention that's probably behind Section 12. And then finally, we're looking at some transition ideas, such as the First Nations Children's Commissioner and an independent child welfare agency. Some infrastructure needs to be in place at a national level to assist us with this reform. We can't just change the legislation and expect that that's going to fix the issue. And finally, I have noted in the brief, we did a YouTube video of a elders conference in December of 2018, and I've given you the link. It explains a little bit about the initiative that we're working on, the hopes and dreams of our communities, and certainly the elders and their vision. So I think it would be helpful for you to understand the work that we're now doing in Nova Scotia, just because I didn't have the time to really go through that. So those are my comments. Thank you.
Thank you, Ms. Cox. Just want to confirm that we did receive your submission. It's being translated, and it will be shared with all the members of the committee as soon as possible. So now I'll ask Mr. Paul Morris to make his comments.
Thank you, Chair. Thank you, Senators. I guess I was asked to come along just to talk about the history of Mi'kmaq family in the province of Nova Scotia and some of the progress both before the amended legislation as well as the changes that have happened certainly since I've been involved with the agency. Just a quick blurb on who I am. I've done child protection litigation for the Provincial Department of Community Services as well as Mi'kmaq family since the late 1990s. It became almost exclusively my practice over the last 15 years. And 3 years ago, I was hired to come and work in-house with Mi'kmaq family full-time. So we now have 4 lawyers doing all of the legal work in the province of Nova Scotia, working under Mi'kmaq family as opposed to private counsel. And part of that is the overall strategy of the agency to bring as many of these things as possible under one roof. The agency was created in the mid-1980s through a tripartite agreement between the federal government, the provincial government, and the 13 chiefs. And it is a agency that it has a board that's made up of the 13 chiefs plus a representative from the Native Women's Association of Nova Scotia. So it is, although it's a separate agency, it still operates under the Children and Family Services Act of Nova Scotia. It still is governed by the policies that are created by the province of Nova Scotia, as opposed to a separate set of policies. And as such, although it is a separate agency that does all of the child protection work on the 13 First Nations geographically within Nova Scotia, it is not completely autonomous in terms of its approach to child protection. And I bring that up just to note that although it operates under the same policies, and certainly as the lawyer who has acted for both the Department of Community Services as well as Mi'kmaq and Family Children Services, it operates differently. And that change in how they approach child protection certainly has become more market over the last 10 years. When I initially began working with some of the other lawyers that were working in this field and started working for Mi'kmaq family, it was a smaller organization. Workers had huge caseloads compared to their provincial counterparts. And I think that in itself led to an approach to child protection that perhaps wasn't always focused on the least intrusive options that were necessary, but more about getting the work done as quickly as possible to try to keep up. As well, through that, I think a lot of the policies that were applied more with less of a critical eye. And so you would have situations where I think you had a lot, when I started out, probably 75 to 80% of my files involved kids in temporary care and custody. So the children, there'd be protection concerns identified. The agency would come in, remove the children, and try to address the situation before putting the children back. That approach to child protection, and this is before the amended legislation that the chief has talked to you today about in Nova Scotia, which came in March 1, 2017. But probably around 2010, 2011, the agency was able, through a cooperative approach with some representatives from the province, to convince the federal government that we were underfunded. And I believe eventually one of the individuals from Mi'kmaq family was one of the witnesses in the Canadian Human Rights Tribunal to demonstrate the case that was brought forward. But we were able to get more funding, hire more workers, and at that point it seemed that there was a better ability to begin to take a less intrusive approach to addressing matters. And when I say that, the legislation didn't change, the provincial policies didn't change. But as a worker in the field, I think there was a change in terms of the direction that was being provided in terms of when you get in there, take the time to sit down with the family member. If the mom or dad is not able to look after the child, then take the time to have some discussions, make some phone calls, find extended family. And again, the policies that are in place often require that police record checks are completed, that there be no child protection history, that they can't have a criminal record. I think it's in the last 7 years, not just 5. And so when you're doing those checks and you have an hour to 2 hours to do it, the minute something gets red flagged or comes up, children were being taken into care. Instead of having that situation where a worker is sitting and continuing to make calls, track down family. And now it is very uncommon for there to be a taking into care versus a customary care or a supervisory placement with some sort of a extended family or community member. And I only state that because I think that's part of the importance. Legislation is one piece, but how it's interpreted and acted on in the field is probably more important than the legislation. And as long as the legislation keeps things moving forward, I think it's a positive thing, certainly to allow the initiative that's going ahead in Nova Scotia for the potential for a Mi'kmaq Act. But we also have the benefit of having an agency in place already that is already incorporating in the policies. I know through my employer, we work together with the Assembly of Nova Scotia Chiefs to try to ensure that we're meeting the right balance between keeping children safe, but while making sure that we do everything we can to keep them with family and community. So through this process, I tallied up my files last year. I think it was in May. And of the files that I had last year, 46% were supervision orders. 29% were customary care supervisory orders, which means the child's been removed from mom or dad, but placed with some other family or community member. 12% were temporary care and custody, where the child's been removed from the mom or dad, but of those 12%, they were kinship placements. So for one reason or another, most likely funding, financial issues, the family chose to go that route, even though the child's still placed with an aunt, uncle, grandmother. 13% of the files were non-family foster type placements. So it's almost a complete reversal from 20 years ago when I started, where it would have been 75 to 80% were temporary care and custody, and 25 to 20% were supervisory orders, to almost a complete reversal. 87% of the files that we had before the courts involved children still placed with family in some capacity, whether it be under supervision, customary care, or temporary care and custody. So it is an opportunity. It is important as well, and to speak to the funding piece, and I know I'm a few minutes over time, but the notice to band is something that was part of the amended legislation that came in March of 2017, but there's no associated funding or federal support for that. It's provincial amendment. And so we have varied responses from each of the First Nations in terms of what that means. And we have some communities are sending someone to court as a representative of the band. Other communities are not. There's no formal infrastructure, funding, education, those sorts of pieces. So again, the legislation is one piece, but then providing the funding so that the actual service can be provided or for the community is also extremely important. And I'll conclude my comments just by mentioning the customary care placements. That was part of the legislative amendments that actually provides for customary care placements for Mi'kmaq children as an option. When it came in, there was no funding associated with it. Part of the goal, I know, in seeking those amendments was to ensure that there was another option that would allow, at that time, if a child was placed with extended family under a supervisory order, there was no financial assistance provided by the agency. You would still be reliant on the band or other sources for assistance. The hope was that there would be funding. It took about a year and a half, but again, it required the province to bring in place an alternative family care funding plan for non-party supervisory orders, where when family gets a placement instead of foster family, there was funds provided with it. And once that was provided, then the feds will match it. And we're still in that situation where they're looking, is the province doing it? If the province is doing it, the funding will flow. If the province isn't doing it, it's a much more difficult negotiation in terms of getting services in place. So we do have things the province doesn't have under prevention, those sorts of things where we've been able to negotiate funding. But again, the legislative piece is one part of it, and then the actual policies and funding that flow out of that will be the bigger piece in terms of affecting real change. So thank you, and those are my comments.
Thank you very much for all three of you. I'd like to open the floor for questions, beginning with Senator McFedrin, followed by Senator Laboucaine-Benson.
Thank you very much, Mr. Chair. Thank you very much for coming to be with us in person. It's very much appreciated. I'm struck by the comment that you made, Ms. Cox, about the UN Declaration on the Rights of Indigenous Peoples and wanting to see it inserted into the body of the bill. And could I just ask what it is about the preamble that references the declaration that is not sufficient? If you could just help us understand a bit more your reasoning for a specific insertion in the bill as distinct from the reference in the preamble to the application of the declaration.
Sure. So with respect to section 18 is where I actually would like to see the insertion. So right after, so if we look at 18.1, right after the reference to the Constitution Act 1982, we're asking that and the UN, the United Nations Declaration on Indigenous Peoples be included, just because from a legal point of view, the United Nations on Declaration on Indigenous Peoples to us represents a stronger legal footing, potentially, than the Constitution Act. So that it's just a bolstering of that and a recognition. And as you know, it's been we've been seeking the recognition of the United Nations Declaration for some time.
Just a supplementary question to that. You're familiar with Bill C-262
Right.
that was introduced by Romeo Saganash and is sponsored in the Senate by Senator Sinclair. You may also be familiar with the unfortunate reality that partisan tactical delays have made it thus far impossible for us to do our job of fully considering Bill C-262. Let me take an optimistic note on that and just pose a hypothetical. In the event that before Parliament adjourns for the election, in the event that indeed Bill C-262 becomes law in Canada, would you see that bill as law in curing your concern, or would you still want to see specific reference in 18?
I think as a lawyer and as an individual who's working in the system, when you're clear within the document that you're working in, then it makes it clear what the rules are. So I guess it doesn't necessarily cure. I mean, if 262 passed, that would make life a little bit easier for us. But at the end of the day, there's no reason why it shouldn't be referenced in C-92 as well, because it is that we're talking about inherent jurisdiction. So there's no reason not to be clear when you're drafting a document. It doesn't help when you don't include as much detail as possible.
Thank you. That's really helpful.
Thank you.
Senator Leboucaine Benson, followed by Senator Coyle.
Thank you, Chair. So I just want to start thanking Chief Prosper for your presentation today and the reminder that the ability to raise our children is the cornerstone of our humanity. That was a very powerful statement. And you also referenced family group conferencing. And in my past life, I was very involved in the training of FGC facilitators as a restorative practice. At my agency, we would have called it a PAMATSO and a Cree word, PAMATSO, family reconciliation process. So thank you for bringing that up. And Mr. Morris, I just want to thank you also for the practical information of the day-to-days of doing this work on the ground and how important it is. And in Alberta, we talked a lot about slowing down that apprehension process, not making quick decisions, thinking about it, talking about it, and trying to place children in their own families. And those stats that you cited are amazing. 87% of children placed in their own families. That's I applaud that. That's significant. Thank you. So my question, though, is for Ms. Cox. I think actually the amendments that you proposed are measured and reasonable. And I want you to talk a little bit more about standing, because this was an issue that I saw in this document. And particularly in Alberta, non-Indigenous foster parents have no standing currently. The way that this legislation is posed, it would elevate non-Indigenous foster parents to have standing in the court process. Can you explain that a little bit further?
Well, I mean, there's no doubt, and I think Mr. Morris and I both can probably speak to this equally. But there's no doubt that it's not clear that non-Indigenous foster parents couldn't have standing. So the way that the care provider is defined does not exclude that group of people. So to me, that they could have standing within a proceeding. And I think what people need to understand is that the more time that you need in court, because everybody's voice has to be heard, the more delay that represents for the children in the placement. And although well-meaning, sometimes non-Indigenous foster parents can be, quite frankly, culturally inappropriate in some of the submissions they make and not trauma-informed. So it can cause delays that we really, and I think from the province of Manitoba, because they do have that ability to have legal standing in a proceeding, we can learn from that example that it's not a good idea to do that.
I do have one more question. One of the other things that I've been thinking about in this bill is children who are currently in care and the need for a legal access order. If we really are talking about the importance of family connection, I wonder what you think about having something more formal around families being able to access a legal standing to say, I want access to my children. We have many in Alberta, for example, grandparents who would have liked to take custody, weren't allowed to take custody for reasons that you've talked about. And they have no way of really accessing their grandchildren to spend time with them. I wonder about having something around legal access orders, what you think about that.
Well, there's a lot of technical pieces that go with that. So, for example, in the province of Nova Scotia right now, so if Bill C-92 passed, we could make our own laws and we could address a lot of these things. But right now, we're bound by the Nova Scotia legislation, which prohibits contact post-permanent care. So if you're permanently in the care of the minister in the province of Nova Scotia, the judges are not allowed to make any kind of orders for access. The only way we can work with that, and we do, is we work on cultural connection plans that will permit the going back and forth between the communities, or we will look at family placement. So we will actually look at approaching the agency, or the agency may approach family members. So perhaps during the initial proceeding, mom and dad didn't identify a family member. We've now found a family member who's interested in a placement. We'll look at terminating that order and placing them with the family member. And some of the tools we use to do that, for example, is the family group conferencing, or the Wigmanage-Gigmana. We will use that as a tool to bring people together, to make the planning, to talk about the legal processes and do all of the things. So there's options, but they're not in the legislation. We have to work around the system.
Right.
And unless Bill C-92 passes, or our Indigenous laws are recognized by the province of Nova Scotia, we couldn't do anything that would allow us to have a specific legal access order that we have to work around it.
Exactly.
I don't know if Mr. Morris would have any.
I guess the other piece, certainly in Nova Scotia, if there are extended family that they come to court, they're allowed to come into the court appearance. They're not excluded from the process. So, in my experience, that in Nova Scotia, certainly that's not an issue. The only time it really becomes an issue is if the agency is not supportive of that extended family placement. Then they would have to apply for standing to participate in the proceeding at that point. But as of not by legislation, but as of practice, the judges are more than open to having extended family, and on some of my proceedings, members from the community that are invited by the parents. So,
Good. Thank you.
Before I go to Senator Coyle, I'd like to take a moment to acknowledge the presence of teachers and students from Central Wellington District High School in Fergus, Ontario, the hometown of our colleague, Senator Rob Black. The students are learning about Indigenous peoples in Canada, and as such, the focus of the trip is learning more about First Nations, Métis, and Inuit in Canada, but also learning about the Canadian parliamentary system. So welcome to the Senate Committee on Aboriginal Peoples. So I'd like to turn over to Senator Coyle and then Senator Doyle.
Thank you, Mr. Chair, and thank you for these really helpful presentations this morning. Chief Prosper, my neighbor, Ms. Cox and Mr. Morris. It was such a well-rounded presentation. I think for all of us it was very helpful, and it was important to hear the progress that has been made in Nova Scotia, and both in terms of the concrete impacts of the changes that have been made, as well as the processes that have been put in place that have helped you get to where we are now in Nova Scotia with the legislation, but also how child and family welfare is practiced in a collaborative manner. I really very much appreciate that. I wish we did have your written presentation in front of us, Ms. Cox, because I'm really looking forward to looking at your fine details. But we will definitely look at that. For Chief Prosper, I believe I heard you say that you're supportive of Bill C-92. We've heard that nobody here is going to pretend that it was actually co-developed. Okay, we understand that, and that's a flaw. That's a flaw. We hope that what comes next will be co-developed. I think that's what we're hearing from you, and that's certainly something that we can make a recommendation about. We're hearing that legislation is one thing, but funding is really critical. Education, capacity building, governance, the various things that have to flow after this are very important. One thing that you said, Chief Prosper, really struck me. You don't want this bill to interrupt progress that has been made. So I have two questions. My first question is about that one. How would you see, let's look at both sides of that coin. What is that concern? What is it potentially in this bill that you see that could interrupt the good progress that we're seeing in Nova Scotia? And on the flip side of that, how would you see this bill enabling, in a positive way, progress to continue in a way that perhaps wouldn't be possible without this bill? So I'm just curious from your perspective.
Sure, and thank you for that. Basically, what I mentioned in terms of this bill hopefully not hampering the progress we made within Nova Scotia, there has been quite a history with the province. I must admit that the Department of Community Services, right from the ministerial level right on down, has been cooperative and really seeking out in a collaboration with the Mi'kmaq within Nova Scotia. And thus, it's that attitude and that spirit that has allowed this progress to be made. As it relates to the bill potentially hampering some of the progress, as mentioned before, and I think Mr. Morris might be better suited to answer this, but for example, there might be certain problems with respect to notice. So we have notice that each of the bands get through the amendments to the Children and Family Services Act. It's one of the 25 amendments. But it's not at all clear, and I do believe, and I look to Mr. Morris on this, that those notice provisions that we have under the Provincial Act, I think this bill provides some uncertainty with respect to the application of that. But more generally, as it relates to, I believe, the enabling aspects of the bill, I think it's welcomed. I do think this bill provides a necessary sort of contribution to the dialogue of the inherent right that the Mi'kmaq and Aboriginal people have over children and families and youth. And that, this bill can certainly contribute towards that. What we're looking to do is have a coordinated approach. So there are gains provincially that we have, and which we're endeavoring to implement. It goes to the point of legislation isn't everything. We do need that capacity and support to implement those changes, especially at a community level. And so that bill would sort of act, in unison with our gains provincially. But maybe I'll look to Mr. Morris to provide, or Ms. Cox, with respect to the notice provisions and the interplay of that.
One of the things when we were reading through C-92 that and I think Jennifer had touched on it in her presentation was under Section 12. It appears to limit the amount of identifying information that can be provided when notifying the band of involvement. And certainly one of the goals in getting that amendment in the Children and Family Services Act for Nova Scotia was to ensure that the band has an opportunity, especially in a situation where it's a housing issue, or lack of housing, inappropriate housing, or condition of housing, where the band has notification and can reach out to the parents and get in there and start helping to address that right away to reduce the amount of time. And so I guess it depends on what Section 12 means in terms of personal information, because depending on how you read it, it almost sounds like you can't even identify who it is. And maybe I'm misreading it, but that's going to limit the amount of information that can be shared to ensure that the band can step in and perhaps help with that. Another one would be, it's not a gain that was obtained through the amendments, but the mention of foster parents potentially being meeting the definition of a care provider under the enabling legislation. The Nova Scotia Act, as it's now written, provides that foster parents are not parties. It specifically says, but not a foster parent. And the reason is they are there as temporary care providers until the family's ready to have addressed their issues and have the children return to the home. And the last thing I think the process needs is another party involved arguing against children going home once those concerns have been addressed, because their rights were created as a result of the children being removed and placed with them through a business arrangement, not through family connection, community connection, that sort of thing. It's one thing if you're a foster parent and a kinship placement, that's different, but a true foster parent. So I think that's one of the concerns as well, is it potentially opens that door up. And we do not want to, based on what we've heard from some other jurisdictions, sometimes foster parents become actively involved in these proceedings to try to argue children shouldn't go home yet. And that's ultimately the goal of the proceeding, is to address the issues and transition the children home. So,
Thank you. Yeah. Thank you very much. Am I allowed one more? Yes? Okay, thank you. I'll be very brief on this one. The other thing that I heard you speak to, Chief Prosper, and anybody is welcome to speak to this, the progress that has been made with fixing things before they're broken, right? Early intervention aspects, etc. Do you see, or any of you, three of you, see anything in this bill? I mean, obviously, we're not seeing funding yet associated with it. Openings for more support in that area, so that you're having an opportunity to help families and children, as you said, and all of us want to redefine what it means to be human, as you said at the end of your presentation, that humanity is reinforced earlier. Do you see that as possible through this legislation? Anything in this that gives you more scope for that?
Sure. And thank you for that. An elder by the name of Tom Christmas from Eskasoni provided a Mi'kmaq word for this practice, this traditional practice of fixing or mending things before they break. And I haven't forgot that. I mean, as mentioned earlier by Ms. Cox, we had an elders gathering, which is available on YouTube, and the link is provided. But within those gatherings, you're privy to the knowledge with respect to how change can be made, and how change exists, and how it takes place within community. And so when I think of this bill, and when I think of things like Wigamanech, Gigamana, family group conferencing, which is embedded certainly within provincial legislation, but I do think we're able to take that further and elevate it under this bill. So I definitely see this bill being that mechanism to sort of institutionalize our practices, our ways of bringing families together and mending things that are broken, are ready to break. So I see that as certainly a benefit, and look to others to add if they want to.
Well, I think what I would say is that Bill C-92 gives us the space to develop our own laws and policies, which will then go to those preventative techniques. So, for example, the customary care amounts that we're always going to want customary care, but we'll be able to dictate what the policies are with respect to who can be a customary care provider, how much funds the family should be receiving, and when that's to be offered. Right now, we must follow the provincial model. So C-92, with that recognition of the inherent right, will give us that space to make those rules and develop those preventative tools, which we know. We just have been unable to do anything with.
Thank you very much.
Senator Francis, followed by Senator McCollum.
Morning, everyone. Thank you for coming. This is a question directly to the panel. If the choice is this bill or no bill, understanding that such a bill may not come around again for some time, what would your advice be? The government has indicated that they're open to some amendments, but time is also running out.
Maybe I'll begin with that, and thank you. We do realize that no bill is perfect. I mean, and I believe I heard that on previous submissions that I tune in on. So, there's going to be a bit of growing pains here. I mean, as I understand, this is the first time federal legislation has been considered with respect to child welfare. The suggestions we've made to the legislation are strategic. We recognize that given an ultimatum, a bill or no bill, I mean, we certainly are for this bill. I mean, with the caveats of funding and transition and the points that we have made, because we do believe it provides a foundation for us to build upon, certainly within the context of Nova Scotia. So that's what I would add to that.
I think that the question that you pose is one that is appropriate mostly for leadership as opposed to folks like myself, technical. But I can tell you that the message that we have received is that it's really, really important that we have the rights recognition that Bill C-92 provides, and we're quite happy with that, but we certainly really would love to have some funding too.
Senator McCollum.
Thank you. Thank you for your presentations. And I wanted to commend you on all the hard work that you've done and that your province seems to be so much further ahead than other provinces. And I think it's mainly due to the provincial government working beside you. And I'm from Manitoba, and the provincial government doesn't work with the Assembly of Manitoba Chiefs, so they're having a very difficult time trying to work through this bill. But Indigenous people have had to be inventive and work around legislation and, to move ahead, and you've certainly done that. I wanted to look at your in your progress that, in how you have your stats and how they've changed to and that you now have a new dynamic in place and it's a better, you're progressing. How many children did you have in care previously, and compared to the date, is there a decrease?
There's definitely a decrease. I wouldn't have the numbers because when I'm referring back to 20 years ago,
Yeah.
I was one of the associates working in my firm who was working with a lawyer who was responsible for child protection, and then so I wasn't analyzing it from that perspective.
Okay.
I just, that's more of an anecdotal. I know from being involved that the majority of all of the files I went to court on back then involved temporary care and custody, taking into care, temporary care and custody. I don't have the exact date, but I know it's sort of in that 10 years ago, around 2010, and I'm assuming it's right around the same time the funding changes to ensure that they had the proper workforce to provide the work, is when I saw the change in terms of, again, as the lawyer, the instructions I was getting from the agency when we were going to court were more family-centered, less intrusive. And I remember that because I kept asking questions why we weren't, because as a lawyer, I'm trying to follow the rules. I'm trying to follow the directions that I've been given. So I'm asking, why aren't we doing it the way we always did it? And so then I started getting the explanations back. And again, that's where the change, as when I've talked to people about this, I've presented at various places, and I've been out to Manitoba as well. And that's part of what I talk about, is what seems like slow change and too slow change for so many people. It's actually when I started to look at those numbers and some of the change in the feel of how the agency was approaching those things. It's a significant change that I didn't see happening day to day. But when you look at where we were 15 years ago and where we are now, it's a huge change. And it's one of those things that I think it changes worker by worker, supervisor by supervisor in terms of how they think. And as the lawyer on the file, changing how I critically think and ask questions of those workers as they're coming through, because it's not the lawyer's responsibility to do social work. But as anyone who's encountered a lawyer knows, we like to ask questions.
You can have pesky lawyers on the other side too,
And-
bugging them, pushing them.
And that's the irony of this. Ms. Cox used to be on the opposite side of many of my files and was one of the people who started to push the agency about 10 years ago. And again, it was one of those things where if you have the lawyers asking questions, the judges asking questions, suddenly as the lawyer for the agency, I want to have answers. I do not want to be appearing in front of a judge saying, I don't know why we're doing what we're doing. That's what we've always done. I want to be able to explain why it's something that's focused on what the family and the kids need, how it keeps them safe, how it's in their best interests. And you can't keep children 100% safe from everything all the time. And I think that's the thing so many social workers struggle with, is knowing what the right amount of risk is to leave kids in situations. And that's sort of the million-dollar question. Anyway, I've gotten off track to your question.
No,
I don't have
no,
stats, is the short answer.
You're answering it. It leads to my second question. And by the way, I disagree with you. I think lawyers should be social workers. We'd be in a much better place. So thank you for that change. I had to go through the same when I was came out of dental school, and how westernized my thinking was. And it took me about 10 to 15 years to decolonize, to go back to my traditional spiritual way of communicating with patients. So it's something like that. Anyway, with this this change, and when we look at preventive care, especially when some of the determinants involve the social determinants of health, which is housing, food insecurity, parenting, and prenatal care, those fall outside this bill. And also, so much depends on healing of the community members to be able to take back their children. How did you do this in the middle of everything?
It's a very good question. Maybe I'll offer some comments related to that. You can only, I think, you know, the committee is getting a certain sense to how we've approached things with government and the relationship that exists there, but also internally. We have two lawyers that typically are on the opposite side of an issue here. And then when you extend that to community players, you have the agency, you have Mi'kmaq Women's Association, you know, and you have health directors, and you have some very strong players here that have very strong views about what is in the best interest of children and current practices and things like that. So needless to say, some of our discussions were quite active and strong. But as I mentioned before, we were able to put our children in the middle, in the center. And there was that recognition that, you know, yes, we're here in representative capacities for different entities and things of that nature, but, you know, there are certain things we can leave to the side for the benefit of our children. And it was that sort of recognition that seemed to permeate throughout this whole process, which allowed this to take place. As you mentioned, with respect to healing, I've often thought of healing, and I only, you know, we had a sentencing, not a circle involving domestic violence, and in our community. And one of the things that I realized that one of the things that was shared is when healing happens, it almost has a ripple effect, you know, amongst people, amongst families, amongst communities, and then eventually throughout the nation. And you know, in various aspects of this initiative, one can sort of experience that from and see that taking place. So I just offer that. Probably not in full answer to your question, but
If I can add on as well, and back to the changes that happen, it does require actions outside of the child protection sphere, because one of the reasons we started to get pushed a little bit more was the health centers in the community started to actually get funding to provide more services. And as they grew in terms of the service delivery that they had, the agency had to change from its approach, which was go see a counselor in, you know, at this town over here, to, okay, you can go to see a counselor at the health center in the community. And so not only did the service become more accessible, but perhaps it became less uncomfortable for the parents, so they were more willing to access those services. But it took growing pains to get, again, workers to get used to the fact that we're not going to use the people we usually use. We're going to start working with new people. And again, the growing pains were there. to the point now where it's just an automatic. If the family wants to see someone at the health center, it's a yes as opposed to a discussion. Whereas when it first started, it was a discussion. But without that service being there, we couldn't be more culturally appropriate in the provision of those services. We wouldn't have those options that were available. So I think it is important that other fields come forward and push on their end to have that growth, so that you have the ability, the infrastructure that's there in the background to provide that service internally.
Thank you.
I realize our time is expiring, but I can't resist the opportunity to ask Chief Prosper one quick question. And in your remarks, you did mention that one of the reasons that you supported Bill C-92 was because it supports the inherent rights of Indigenous peoples. And I think you were referring to Section 8A, and just for your reference, I'll read it. It says, the purpose of this act is to A, affirm the rights and jurisdiction of Indigenous peoples in relation to child and family services. I guess my question, Chief Prosper, is what seems to be missing in that clause is the word inherent. Mm-hmm. So that word inherent rights does appear in the preamble, but in this particular section, it doesn't appear. Mm-hmm. And I'm wondering if you would support the insertion of the word inherent in that clause so that it would read, affirm the inherent rights and jurisdiction of Indigenous people. So I open for your comment.
I would certainly agree with that inclusion of in affirming the inherent rights of Indigenous peoples, Aboriginal peoples within that particular section. I think it breathes more life into the nature of the right, even though the nature of that right is not dependent upon legislative recognition. I think it would be a positive change in that regard.
Thank you, Chief Paul. We're at the end of our time, so thank you very, very much for appearing. I have to agree with Senator McCollum that your witness and testimony today was most compelling, so thank you very much for appearing. We'll adjourn momentarily while we set up for the next panel.